Welcome to the University of Essex Enterprise Zone. You're at the Space to Grow programme, Investment Readiness. Today we are privileged to be working with SeedLegals, who are an eminent company, and I have with me today Nicholas Richards and Josh Clark to assist me with presentation today. So just to remind you, our Space to Grow Investment Readiness Programme is designed to help both entrepreneurs and investors prepare themselves for investment. And we are specifically talking about equity investment, but we can talk about other sides of it too. This works in conjunction with our Angels at Essex Equity Investment Platform, where we put opportunities in front of registered investors. And we have been very successful so far, raising over £3.5 million for investment into these opportunities on our platform. And that's only since May of last year. So we still haven't reached our first anniversary. So when we're running these webinars, we like to bring along interesting speakers on interesting topics. And today is no exception. I'd like to introduce you to Nicholas Richards, who's Head of Investor Partnerships at SeedLegals. Now, Nick is a chartered accountant and a former VC investor. And SeedLegals is a tech platform that has automated the legal process for raising capital. And in under 4 years has become the largest closer of funding rounds in the UK. So day to day, Nick works with angels, syndicates, seed funds and VC and founders in supporting them to close their round in SeedLegals. So without further ado, Nick, would you like to take over, please? It's all yours.
Brilliant, John. Thank you very much. So as John mentioned, I'm an ex-VC investor myself, and funnily enough, when I was a VC, what I found is that when you are a venture capitalist, you kind of have to be a bit of a jack of all trades. You have to know a bit about everything, and legals is particularly one of them. You can't just necessarily outsource all of that to a lawyer. So I found that particularly painful, even myself, who has been to law school, although I'm not a qualified lawyer. So I actually came across SeedLegals randomly, seeing what they would do to change up the legal landscape for startups and investors when it comes to doing transactions. I fell in love with it, and basically that's why I'm now here working in a business development role. So just to caveat for people today, I'm sure the SeedLegals legal team would want me to say this. I must say that I'm not a lawyer, and anything I'm saying here today is not legal or tax advice. But the information I'm sharing with you, I suppose, is a result of the experience and knowledge I've accrued being a VC and also working at SeedLegals for the last 2 years, where our organization has supported hundreds of founders close their funding rounds. So yeah, just to give a brief background as to, I mean, you've heard about my background, but just again to reiterate what SeedLegals is. As John said, SeedLegals is a tech platform which is completely, I would not only just say automated the legal process when it comes to raising capital or investing, but I would say it's also simplified it and made it a lot more accessible to founders and investors. And basically, if you compare this to the old way, what would have happened is if you're an investor or a founder and you want to invest or raise capital, you would go to your lawyer, you'd get them maybe to draft up a term sheet, they send it over to the other person's lawyer, they mark it up. There's endless back and forth, and that's just for one document. That's not even a legally binding document. The next steps would then be negotiating a series of documents, which generally results in a process that actually takes a lot more time than it should do. It's a fairly manual process, which was ripe for automation. And secondly, it's obviously a very costly exercise because we generally know lawyers are obviously not cheap. And as I say, with this being a very manual task, that makes it even more expensive. So that's where SeedLegals has stepped in to automate this process, make it simpler, more time efficient and cost efficient for founders and investors. And as John mentioned, in terms of our scale, we have 20,000 companies now on SeedLegals. We're the largest closer of funding rounds in the UK. To give you a sense of our scale, in the last quarter, we did 300 funding rounds on SeedLegals, and that sort of similar cadence is applying as of today. So yeah, lovely traction we're seeing in the startup market. It's a separate point, but also if you are a founder and you're looking to, say post a raise or maybe even pre-raise, set up your option scheme, we've also made that option a lot easier for founders to sort now. So that's just a bit of background to SeedLegals. So let me jump into effectively what I would like to talk about today. Now, when I was writing this and thinking about the core documents, whether you're an investor or founder, you should be aware of, I split this effectively into what I would call 2 stages. So pre-deal, i.e. the stuff you should get ready before you really start kind of negotiating terms with your investors. And then the second aspect of it is the actual deal itself. Where there's a series of documents. As I say, it's not that they're all vastly different, but one of the frustrating things about doing an investment into a startup is that there are many documents all containing many similar things, but it's absolutely vital that they all match up and consistent, and that you as a founder or investor understand what they're doing. So without further ado, let's jump into what I call the pre-deal section. And what I should actually say before I jump into this is some of the stuff I'm about to tell you might not necessarily tie in with what you expect of legals. Like, if I was, for example, to say legals, I would think of a contract between 2 parties where people have to sign. And yes, of course, that is, that definitely is within the definition of legals. But particularly when it comes to investing in startups, there are actually other kind of key documents or data sources which are critically important to this process. So that's why I'm going to touch upon some of those today. The first one being, in this instance, the cap table. Now, this obviously is not a legal document. I mean, look, we've got some founders and investors on the obviously on the call, on the webinar today. I won't, give a really detailed breakdown, but just to outline what a cap table is. It's simply a list or a table which effectively describes who owns what shares in the company. So whether you're a founder or an investor, what it's showing on that piece of paper, it's outlining the economic interests of all the shareholders in that business. So as an investor particularly, I want to know who has the most skin in the game by looking at the cap table. And also what this cap table is going to be showing me to some extent is it's going to be outlining the kind of the basic legal rights of the shareholders in that business. So for example, not that I'm going to get too much into the legal weeds, but to approve certain board decisions, you generally need to have shareholder approval of say 50 or 75%, depending on the nature of the decision. So if I'm an investor, I particularly want to know where that power lies and effectively who is needed to get what decisions over the line. One thing I actually always stress to both investors when looking at a cap table, or whether you're a founder looking at proposed terms from an investor, is always make sure you really understand what properties those shares have that are say owned by the founding team, because it's all very well looking at a founder who say owns 40%, but you don't necessarily know what kind of shares that person owns. So for example, they could, do they have voting rights? Do they have enhanced voting rights? Do they get a greater share of the economic proceeds? It's very, very important to understand sort of the economic principles and legal principles behind those share classes. Now, most early stage startups don't really have anything that complex. Everyone just simply has what's called ordinary equity, which effectively means that for one share you get 1 vote, and if there's 1 share out of 100, you earn effectively 1/100th of the company's value. But as companies raise further rounds of capital, what happens is you see new share classes perhaps entering into the mix with different sorts of rights. So it's very, very important to understand from the cap table perspective, say, the full implications of those shares. So you can probably tell from me going on about this for a few minutes as to why it is one of the most important parts of the deal. It's one of the most important parts of the deal, obviously, because if you're an investor, you want to know, if you're investing for equity, of course, what is your equity going to be positioned once you've actually put your money in? How much share of the business do you have, which is going to ultimately govern 2 things: your economic position in the business and control. That's generally what all investors care about when it comes to investing companies: economics and control. So flipping over to the founder side, one thing I always say to founders is really make sure, if you've got an offer on the table, or if you're contemplating a raise and you want to raise X amount at X valuation, really understand how that deal affects your cap table. So for example, how is your voting position affected? Look at your economic position based on your proposed deal or the proposed investor's deal. Economically, is that enough to incentivize you for the future? Now, of course, we would all love to, sort of be, future Elon Musk. So when it comes to negotiating your equity, you probably don't want to come across as naive. And if you'd like some data points on that, you can easily visit SeedLegals' website, where we share that information wide about the average type of equity being given away in a funding round, depending on the size, of course. So, coming on to the last point of this slide, I suppose my other advice when it comes, this is specifically for founders, is really make sure you get your cap table right. And what I mean right, I mean make sure it is up to date and accurately reflects what's in Companies House. You would be amazed by the amount of founders who come to not only to SeedLegals, but I would say to loads of law firms, where basically their cap table either is out of date, the formula's wrong, or something is not quite right. And that really isn't a good thing for a couple of reasons. Number one is, if you show this to investors and then start negotiating a deal only to discover that the cap table was wrong, then that can potentially, change the whole prospects of the deal. So, for example, maybe the investor is getting less equity than they expected, or they're getting more equity than they expected. So, pros and cons for both parties there. It's also not going to put you as the founder it's not going to give a very good first impression if one of the core elements of your business isn't up to date. But anyway, let's assume there were some mistakes in it and your investors were still keen to proceed. All the kind of kinks got ironed out. The problem is that if the cap table is wrong and everything needs to be updated, then that is going to have an effect on all the legal documents, which basically means that all the legal documents need to get updated. Everything needs to be potentially processed by lawyers, or in this case on SeedLegals, it just gets updated automatically. But most importantly, if you were going down the traditional law firm route, it's just going to cost you more because it involves more human hours to effectively correct this exercise. So really make sure you get this right. And I would say one of the most important things is to really make sure yours and your investors' expectations are aligned before going into the deal. So cap table, absolutely critical, get it right. On to the next one. Now, this one might not necessarily occur for all startups, but it certainly occurs for a great deal in the UK. So I feel like we have to talk about it. And this is what's called advance assurance. So before I talk about what advance assurance is, I have to take a step back and tell you effectively what this is related to. So for those who aren't aware, the UK is actually incredibly blessed by a very unique tax incentive for investors in the UK. It's called SEIS or EIS. It stands for the Seed Enterprise Investment Scheme, or Enterprise Investment in Scheme. And what this does effectively, it basically means if you are, say, an angel investor or even a fund investor who invests under this scheme, what it means is that for every £1 you invest in a startup, HMRC is going to give you a certain percent of that money back. You can offset it against previous year's tax. And this tax benefit is very generous. It currently ranges from 30 to 50%, depending on the maturity of the startup you're investing in. So this is an incredible incentive for angel investors in the UK. I think I read some crazy stat that recently said that roughly 2/3 of angel investors in the UK will only invest in startups that qualify for SEIS or EIS. Either way, I hope you can tell from my words that this scheme fuels the UK early stage ecosystem. So if you are a startup and you can raise under this scheme, I would thoroughly recommend taking a look at it. Now, if you do want to do that, what you need to do is obviously prove that you are eligible for this scheme. And there are effectively two ways you can do that. One is you can read HMRC's guidance and say, yep, I feel comfortable that my company matches this, so I'm going to raise under this tax scheme. I'm going to promise this to my investors, and when the round closes, I'll just write to HMRC to say, please, can you give my investors their tax relief? Which can be done. People do it. The only problem is if HMRC were for some reason to not agree with your assessment, then your investors will not get that tax benefit, and you can get, as a result, get some sort of very, very disappointed investors because they've lost that significant tax benefit, which may have fueled their decision to invest in your business. The other thing, though, you can do is called it's called seeking advance assurance, and that is effectively where you, the business, write to HMRC. You have to create an application form, a cover letter, and you basically say to HMRC, I believe I'm eligible for this scheme, please can you confirm? And then what HMRC do is they look at your application and they effectively say yes or no. Now, if they say yes, the great thing for you as a founder is it means you've got that certificate that says to investors, we are SEIS or EIS eligible, and that is going to give a lot more comfort to your investors who want to invest in you. But also thinking about it, even if you're still in the stage of courting investors and looking in there, the fact that you've got SEIS or EIS is definitely going to widen your potential pool of interested investors in your business. So as I said, advance assurance is not obligatory. But if I was a startup, for the relatively low cost it costs to do, or on SeedLegals at least, on SeedLegals it costs £300, I would definitely recommend doing it. And there was a question there earlier in the poll about investment strategy regarding legals. What I would say to anyone who is intending to raise under this scheme, if you're looking to do your funding round in, say, the next few months, I would definitely start your advance assurance application now. If you were to do it on SeedLegals, for example, you can create the forms within literally, I would say, a couple of minutes, but you do have to submit to HMRC your business plan, and then you send that off to them. But on average, to set expectation, we say HMRC can take up to 6 weeks to give a response to your application. So you want to make sure you have that well ahead of your funding round. So that's advance assurance. Now, on to the next step. There are a few basic documents which are actually relatively easy to set up, but you'd be amazed at the number of founders who actually neglect to create these documents. So initially my title for this slide was the forgotten documents, but to make it more catchy, I'm going to put it as the documents all investors want to see before they even consider investing in your business. And this goes to the question I had, which annoyingly I can't do for the poll, but I wanted to ask the question of what are two of the most important things in an early stage startup? Well, there are loads of things, obviously. Is it customers? Is it products? Is it all that kind of stuff? Well, actually, no. With the early stage startup, when it comes to legals, the two most important things are the founders and the IP. And when I say that, that actually relates to two critical documents that you should be setting up and a load of investors will want to see. So the first thing regarding the founder is the founder service agreement. Ultimately, the founder service agreement is a document that governs the relationship between the founders and the company. Now, that statement might sound, quite boring and trite, but it actually really does establish something really important. When you are investing in an early stage startup, let's say you're investing in a team which are pre-idea, or maybe they have an idea but haven't got a product yet, or maybe even post-product. At that stage, one of the most important things of your business actually is the founders. So if they go away, they left the business, that's a lot of value potentially leaving your business. So as an investor, you want some form of protection that the value in your business is preserved. And if you're a founder as well, or a founding team member, let's say if one of your co-founders was to leave, you also want to ensure that effectively the business is still viable and no founder has walked away with a big chunk of equity that no one's ever going to see again. So it's really important to get this up, whether you're a founder or an investor, and to give you a sense of the kind of the key things this covers. It covers things like vesting. So if you're a founder, for example, how much of your shares do you own from day one? Do you earn them over time? If you were to leave the business, how much shares would you have if you left, depending on the nature of how you left? So these are all very, very important things which you can easily set up, by the way, on SeedLegals in a matter of minutes. The other thing is the IP. Now, I'm not obviously, as I said, I'm not a lawyer and I'm not an intellectual property expert, but IP, from my, general sort of professional experience, IP can take many forms, whether it's trademarks, certain assets, code, whatever. Either way, it is critical that that IP is owned by the company, and that is what effectively the IP assignment document is. It's assurance to the investors that the intellectual property is owned by the company. If it were to be owned by the founder, again, it's that same risk with a founder service agreement. If the founder were to go away and basically say, hey, this is actually my IP, that creates two issues. One is you could land up in a situation where the departing founder and the company are debating over who owns the IP, which results in slower progress, potentially time and money spent on negotiating a settlement for this outcome. And then obviously, look, for you as an investor, you want to know that, okay, in the event that a founder or a founding team member does leave, which is a very, very common occurrence in early stage startups, you want to at least know that that kind of core IP still remains in the business. So there's still value, and you can go and attract, say, other new entrants to come into the business and work with that IP to develop the company further. So it's definitely important you get that set up. Sorry, I slightly went up with the bullet points there. But either way, the advice I would say is make sure you get these sorted as early as possible. It really takes only a few minutes to set up if you use something like SeedLegals. So, sorry, I just put some hyperlinks there, which I don't know if they'll be available in the YouTube presentation, but John, by all means, I can send you those links afterwards if you want to embed them. Okay, cool. So we've talked about pre-deal. Now we're actually going to go on to the deal itself. So let's say you kind of got all those kind of pre-deal documents sorted. Now you're in the stage where you are speaking with investors, and it sounds like there's some interest where a deal needs to be struck up. So the first thing you're going to see is what's known as the term sheet. The term sheet is effectively, otherwise known as heads of terms, or I've heard MOU, all sorts of things. In the VC world, it's known as the term sheet. And what this effectively does for both founders and investors, it outlines the key commercials of the deal before ever getting into legals. It's important to note that this document is not legally binding, or it's mostly non-legally binding. I'd say 99% of it is non-legally binding. So founders and investors, if you signed a term sheet, founders, you are not obliged to take the investor's investment. Investors, if you sign, you're not committing to invest in that startup. Of course, so if you do back out, you have to consider what reputational risk that might have for you, but that's all to balance depending on on the circumstances of each deal. So as I said, the term sheet is the doc that outlines the key commercials of the deal. Our CEO actually uses a good dating analogy. If you were to think of the world of raising capital or investing as dating, the term sheet is the equivalent of saying, let's go out for dinner at 7 on Friday at this place. Whereas the legal agreements are saying, I want a house in Gloucestershire with 3 children with a nearby nursery within a 5 minutes drive or something like that. So a term sheet, you really only want to be negotiating, the kind of the key things at this stage. So everyone's expectations are aligned. It would be silly to negotiate a big long form legal document only for it to fall over. So in terms of term sheets, they can be applied for different types of instruments. So I think John said earlier there that specifically this workshop is confined to realms of equity. So you can have obviously a term sheet for equity. You can have a term sheet for a convertible loan note, which does happen with some startups, albeit it's not as common as equity. And then the other thing I would flag to founders on this call is raising by what's called an advanced subscription. So basically this is a form of investment which is compatible with EIS or SEIS, and that's effectively where the investor is giving you money but not taking equity straight away. Rather, they're giving you money and it will eventually convert it to equity at an agreed valuation, or if there's a new funding round, an investor comes in with a new valuation, it will convert at that basically. But getting away from those particulars, what I've illustrated in the bottom of this slide is the key things to be looking out for when it comes to looking at your term sheet, or if you're an investor, what you should be proposing in your term sheet. So I'm not going to go through all these in massive detail, but I've put some key things there. So obviously the valuation of the business, that's definitely a key thing that should be in the term sheet, and also the economics of the proposed equity to be taken. So for example, founders, is your investor looking for preference shares? Are they looking for a liquidation preference or something like that? It'll also cover things like vesting. This is very common, I would say, for startups generally all the way up to seed stage, sometimes maybe Series A, I don't know. But vesting effectively covers for you founders how much shares you own from day one and how you earn those shares over time. The other thing, going on to that point about control, so economics and control, it will cover things like what the board looks like and what approvals are needed to make certain decisions at a board and shareholder level. The next point is investor consent. So that is, are any of your proposed investors asking for effectively that certain decisions need their consent regardless of the other people in the business? And then the final thing is warranties. So as a founder, what are you on the hook for to your investors? Were you to say make a material misrepresentation to the investor, and effectively you have to pay the investor back something. If you want more details on that, I say in the bottom I had a link here where we have loads of detail on all the kind of things that are negotiated in term sheets. And if you want our guidance, obviously by all means hop onto SeedLegals and hop onto the live chat to find out more. So that's the term sheet. It's actually quite a big milestone to get to the term sheet. There's often quite a lot of toing and froing. And then once you have the term sheet, it basically forms the foundation for populating the rest of the legal documents. Now, before you actually get to the final legal agreement, one of the common things you'll see in this stage is what's called the disclosure letter. So for founders, this is effectively you signing a piece of paper which has a bunch of statements on it representing to the investors that there are effectively no hidden nasties in the business, or if there is something that you feel the investor should know before signing the legal document, you tell them now. So the common kind of things you'll see in here, for example, are, does the business have any loans? Are there any sort of liabilities that they haven't paid for yet, or do they have no liabilities? So this is a kind of a fairly standard letter, but investors, you should definitely ask for it, and founders, you should expect investors to ask for it. Again, this can all be created on SeedLegals. Then once you kind of got past the disclosure letter, you get to the actual long form document itself. So the actual legal document which is governing the terms of this divestment. So it's known as the Shareholders Agreement. So what you'll have in this document is, largely speaking, what you agreed at an informal level in the term sheet, now all transcribed into fancy legal language. There will also be some more nitty-gritty things that both founders and investors will have to consider when it comes to drawing up this document. So by all means, if you are, depending on who's doing the drafting here, whether you're founder or investment, don't necessarily just think the shareholders agreement is a legal, one-to-one translation of the term sheet. There'll be other stuff in there, so it's very, very important to review that and make sure you understand the terms. The other thing to pay attention to as well is the actual company articles itself. So for those who aren't aware, the company articles are effectively the laws that govern how that company is run. All companies certainly should have articles, but if there is a new funding round, what often happens is there are new rights that might be negotiated by the investors in that round, which not only need to be in the shareholders agreement, but also need to be in the company articles itself. So it's absolutely important there is consistency between the deal docs and the corporate governance documentation. The other thing, I went back here. So the other thing as well, this is actually a relatively lightweight document. It's the resolutions, but it's actually incredibly important. So if you are a founder and you're doing a new funding round, I would consider it very, 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 very likely that you need to either get board and or shareholder approval to approve this transaction, because what you're effectively doing is you're issuing new shares to shareholders. So you definitely need to get those resolutions in place and signed. And if you're an investor, you should be asking to see evidence of those. You don't want the situation where this hasn't been done, and then some shareholder might argue that this whole funding round was completely invalid because it was never actually approved by the board and all the shareholders. So definitely make sure you get those done. And then this is the final thing, which is incumbent upon the founders, but investors should be aware of it as well, is that if you are issuing equity, obviously you need to file a form to Companies House to say we have issued new shares, and we are issuing new share certificates to our investors. Investors, you obviously want to have evidence of your share certificates. And if you are investing under SEIS or EIS, you will want basically a certificate from HMRC, which basically proves that you can claim your tax relief. And this is something typically undertaken by the company, the investee company, post the funding round, which again you can do on SeedLegals. So that's effectively is the summary of where we're at. As I say, I think it's those pre-deal and deal documents. Look, with every deal there can be other things that come into play, but I think those are things that are perennial to startup transactions. So I will leave it there. I hope everyone has found this useful and informative, and let's try and answer some questions. I hope they're not too technical, given I'm not the lawyer, but I'll try to point you in the best direction as I can.
Okay, thank you, Nick. We've got a couple of questions regarding the cap tables.
Okay.
And the first one is from Alan Smith, and he says, does the cap table include total shares to be vested, say, over 3 years? And this probably answers the second question, is the cap table showing the proposed shares if the investment goes ahead, or the current shares without the investment?
Sure, absolutely. So in terms of the, I mean, look, yeah, there are various versions of the cap table. When you as a founder, if you're showing something to investors, they obviously want to see the current state of the cap table. But yes, definitely, if there's a deal in discussion, of course, if you're both an investor and a founder, everyone wants to see effectively what the pre and post funding cap table looks like. So, what does that mean for everyone economically? What does that mean in terms of, the dynamics, in terms of voting? So yes, pre and post funding is absolutely key. In terms of vesting, I'm pretty certain, let's say if you're a founder that owns 40% of the shares, I'm pretty certain the cap table will just show your position as if you own them, and the vesting is pretty much a separate thing. I'm very certain that's the case, although by all means you could confirm that with someone at SeedLegals.
I think you may possibly want to show both, the before and after.
Oh, absolutely, absolutely.
The before must be confirmed by Companies House and your structures and everything else, and the after is where you're going and what effect that's going to have on you, Mr. Investor, on what you're investing.
Absolutely.
I think before and after is probably a belt and braces approach.
Absolutely.
It's the approach I would favour.
Yeah, absolutely.
Moving on to HMRC, SEIS and EIS. Has there ever been a situation where advance assurance was given, but then later it didn't qualify? And if so, what should a business do then?
That's a good question. So let me first of all say that I'm not the SEIS or EIS expert here. So if you wanted a more detailed answer than maybe what I'm about to give you, feel free to tap them up. But from my knowledge, what I can say is that I suppose if I was applying for advance assurance and HMRC granted it, then I wouldn't expect that status to change in the short term. But do bear in mind that if you are applying advance assurance, I believe that status of approval by HMRC only is available for a finite period of time. So I can't remember the exact time, if it's 6 months or 12 months or something like that. So it's a good point. If you are raising for advance assurance, make sure you apply such that your window of eligibility ties in with the time you're doing a funding round. Has there ever been a situation where, say, you've applied for advance assurance, HMRC says yes, but then has a knee-jerk decision very shortly and says no? That I wouldn't know the answer to. I consider that highly unlikely. And if so, you then want to be debating as to why they said yes in the first place.
But I mean, so the situation could arise where investors become directors and things like that, which can affect some of your status with these, which leads me on to a very an interesting question. Can a founder invest in their own startup via SEIS or EIS?
That is a good question to which I don't know the answer, but I think we definitely have that covered in our FAQs on SeedLegals. So apologies, I can't give the answer here, but I'm sure you'll be able to find that either on the website or just hit up live chat and someone will be able to help you out there.
It would all hinge really on whether or not the founder is actually a director of the company, because that actually affects their CIS and EIS status for investors. So I would say probably not, but yes, take extra advice on that. And we do actually run a session on SEIS and EIS with the accounting firm BDO, with their tax specialists from Ipswich. And you can catch that up on our YouTube webinars if you check that out. Moving on to actual SeedLegals as well. How does SeedLegal terms and legal documents tie in with crowdfunding platforms such as Seeders or Crowdcube? And a straight question, can founders use SeedLegals to raise on these platforms?
So the answer is absolutely yes. I think as a business of SeedLegals, we know crowdfunding has become increasingly popular. So I think we'd be mad not to create a solution whereby founders who are raising both in the private and the crowd markets can do all of that on SeedLegals. So absolutely yes. If you let's say if you're a founder and you're wanting to raise through the crowd, what you've got to bear in mind is that if you want to raise through the crowd, you generally can't just go raise on the crowd straight away. You have to have a certain amount of private backing. So what you can do on SeedLegals is effectively, if you've got your private investors lined up, you can get all your deal documents sorted, and then effectively you're sourcing crowdfunding money in. That's not a problem. We've effectively created a one-click solution such that if you're the founder and you're taking Seeders money, it's literally just a matter of clicking, we've got Seeders money coming in, and then our platform automatically populates all the wording that Seeders need to see in their legal documentation, and or Crowdcube, by the way. We work very closely with the crowdfunding platforms in that respect.
Okay, so we're moving back to our SEIS and EIS advanced assurance. It's going to be a hot topic, which you're not the expert on.
I should have bought
But as I say, we do have a webinar on this. Yeah. But when applying for advanced insurance, I mean, so the question here, and I'll rephrase it, is currently HMRC require a specific investment to apply for advanced assurance. If you don't have an investor ready, how do you get advanced insurance? I'll leave that one open to you.
That's a good question. So look, I think from what I see being advice being given to founders is that yes, you do have to have some sort of investor lined up. Because ultimately what could happen is then anyone could just apply, and HMRC only have so many hours in the day to process all the applications. So what they're trying to dismiss there is effectively speculative applications. Having said that, what I do think is positive for HMRC is that you don't necessarily need to have any I don't believe you need to have any agreement in place at all. If you so much as had a phone conversation with someone says, look, I'm interested in investing 100K, that we generally advise people they can do an advanced assurance based on that. And look, if that investor ducks out, it's not a problem. If a new one comes in, and likewise if the commitment they said has changed slightly, again, that shouldn't necessarily affect the application. The whole point of this is understandably HMRC just want to dismiss speculative applications.
That's quite understandable because they do have limited resources.
Exactly.
And they don't have any time to answer any questions.
Well, I mean, in a previous life, by the way, before being a VC, I used to be a tax advisor, and I mean, there were certain phone numbers it was quite hard to get hold of someone. But I will say, actually, with at least the advanced assurance team at HMRC, I don't know if they have a Twitter account where I might get praised by them, but to manage customer expectation, we do say it can take HMRC up to 6 weeks. But we've actually seen people at SeedLegals get their applications approved within a matter of days. Now, I'm not saying people will get their applications approved in a matter of days by going with SeedLegals. But I say if you kind of hit HMRC at the right time, I say it can actually be done surprisingly quickly.
Okay. Couple of questions come in which are slightly related, but they are separate. Okay, yeah. I'll take them. I'll do this one first. That the company is over 2 years old,
Yeah.
They believe that makes it ineligible for SEIS. Can they set up a subsidiary company in order to claim SEIS for the subsidiary company?
Yeah, unfortunately, I'd love to be able to answer this question with certainty. But I'd have to give the same answer, I'm afraid, is that I'm pretty certain you'll be able to find the answer to that on our website, or if not, literally just hit live chat and someone will be able to give you some advice on that.
Okay, no, that's fair enough, because I think we're labouring on the SEIS too much at the moment.
But it's a hot topic in demand, and so I'm glad at least we at SeedLegals are making it easy for people to find out these questions.
Okay.
Not through me though today.
Okay, now a nice, but it follows on from that one, but it's a little more complicated. Okay, but you may be able to answer it. Calculating a valuation on a business when it's actually been registered as a new company for a new venture.
Yeah, fine. So we're talking. So for the context here, do I assume we're talking about we have a company, we have people who are working for it, but there is no idea, there's no customers, there's no product. How do you value that sort of thing? Correct?
Yes.
Great question. So let me caveat, I think, first by saying that I think a lot of people would say valuation is a bit of an art, as opposed to a science. And look, loads of people will give you different views on this. I think I was speaking to a pre-seed investor actually recently, which actually, when we talk about pre-seed, that's effectively kind of what this company is. It's some people with an idea. Rather than think about valuation, first ask yourself this question, which is, how much money do I need to raise to get this off the ground? And I'm not talking about I need 10 million so I can have offices in Hong Kong and Germany and Singapore in the next 3 years. Think about it in terms of what raise do you need to get to the next critical milestone. So, like, for example, is it what money do I need to build my product, build my MVP, take it out to market, or something like that? Then when you've got that kind of sum in mind, ask yourself what percentage of equity you'd be willing to give away for that. Now, obviously, you can't be totally naive and say, like, I want to raise 150K for 1% of my business, because unless you've come up with you've managed to convince your investor, you've come up with the way of turning lead into gold, chances are you're not going to raise money at that valuation. So do think about, obviously, what you'd be willing to give away, and then just do a bit of research. We've actually got tons of resources on our website which show kind of the average amount of equity being given away depending on what stage of funding round you're at. So pre-seed, seed, Series A, and the median kind of equity is about 15%. So basically, let's say if it was the 15%, and you say, fine, okay, 100K buys 15% of my business. I've just chosen some really unfortunate numbers there now because then I have to do the numbers in my head. But either way, you can gross that up to effectively what your valuation should mean there. And look, the other thing I should also bear in mind as well is that when you are having discussions with investors, this is also some good advice given to me by pre-seed investors. Don't necessarily be hard and fast about a certain number. Think of it in terms of a range. Think of it as I'm realistically looking to raise between X and Y, and I'm willing to give away between X and Y of my company. The nice thing about that is you're not committing to anything as a founder per se. And the nice thing as well is if you're in the fortunate position where you've got a lot of investors vying for your attention, then you can effectively play off that competitive attention to negotiate a better valuation for yourself.
No, but that is very, very valid. And I'll just mention to Catherine Patterson, who very kindly said that she got her SES assurance herself within a week, which only goes to prove, which is our evidence as well. You can get it very, very quickly.
Yeah.
But she also caveats that and says her company is 9 years old, but not trading yet.
Yeah, exactly.
That's the answer. If the company's not trading,
exactly,
it's still regarded as a startup. Indeed. And this is one of these little anomalies of tax system and support systems. There are different ideas of what constitutes a new business. Yeah. And I think that, even in the business support arena, anything up to about 3 years old is still eligible for a startup loan and things like this, provided they have not traded. If they have traded, I think it's up to 2 years now. So
Yeah.
it's moving goalposts all the time.
Indeed.
So
Indeed.
yeah, there are lots of intricate and different ways of dealing with this. Well, Nick, thank you very, very much indeed for today. I don't see any more Q&As coming in, so I thank you very much indeed. I found it thoroughly entertaining, and yes, I was watching the whole thing entirely. And can you just say for the audience, how can they best contact you to find out more?
Sure, absolutely. So look, if you are an investor and you're wanting to know how to structure a term sheet, send out a term sheet, by all means, I would say contact me. I'm Nicholas at SeedLegals. I handle basically all kind of investor relationships here at the company. But look, if you're a founder looking to raise SEIS, EIS, if you're wondering how best to set up your round, whether to go with advanced subscription, equity, or if there are other things like setting up your option scheme, by all means, just go on SeedLegals, hit the live chat. You'll speak to someone within under 2 minutes. We have a dedicated team of customer support who have supported hundreds of founders close their rounds or set up their option schemes, and a legal team to help with the extra complex matters. So we're here to make this whole process a lot simpler and easier, so founders can basically spend time on what actually matters, which is running their business.
Okay, and the best point of contact, the best email address?
You're literally just best going on to the SeedLegals website. On the right, in the bottom right hand corner, is the intercom button. Of course, if you do a funding round with SeedLegals, you have dedicated account managers. So that's why I suppose I'm not giving out a name, because the name will be dependent on who you're speaking to at the time.
Well, thank you very much indeed. For those of you who are chasing for the slides, as I said at the beginning, the webinar has been recorded and you will be able to view the slides again in the YouTube channel going forward for that. Once again, Nick, thank you very much indeed. It's been a pleasure. Josh, thank you for managing the IT today. And it leaves me to say, safe journey. If you have to make a safe journey, keep safe. Keep to the rules. It's for the benefit of all of us. So thank you once again. I look forward to seeing many of you again at our next webinar on the 9th of March. And please don't miss that. So take a look at our website. Thank you very much.
Thanks, John. Thank you, Josh.
Thank you.
Take care. Take care, everyone. Bye-bye.
Bye-bye.